Okay, my name is Mr. Max Chaudhary. I'm one of the lawyers at Chaudhary Law Office, and I want to welcome you to this Q&A webinar. One thing to keep in mind, which I think I will also reiterate in the chat, is that portions of this recording will end up on social media. So if you don't want your image or your voice on social media, then you may want to mute and get rid of the visual from your side. Just because, you may be surprised if you do see this, because portions of this would end up on the internet for the purpose of letting people know that there is services that we offer. And this is meant to provide general guidance. So what that means is that because we can't always get the precise set of circumstances for this, then which means consequently we can't really give advice, but we do give general guidance because advice requires really substantive understanding of your individual background and circumstances. So with that in mind, what I would suggest is if everybody can mute their microphone, just because, as I said, it may be on social media eventually. Then also, in terms of like the format of this, I will start with the chat. Please pose questions in this chat. And that would be, I think, ideal, because then I can see it in sort of black and white virtually on the screen, and then I can kind of digest the question. And as is necessary, try to pose answers and get background. Sometimes I need a bit of background to get an intelligible answer that might be useful for you. With that in mind, I'm assuming everybody can hear me because nobody's complaining. And from time to time, people may come and go and enter the chat and the call, because people obviously want to deal with their particular questions and maybe not want to have any other kind of interaction, which is fine. So for anybody joining, please feel free to pose questions in the chat, and I will try to respond to them sequentially for this. And as I want to maybe put the sort of caveats in the chat, this is being recorded, and because it's being recorded, and as such, your voice and image may be on social media, and and then this is a specific reminder. I just want to it's better if you can sort of pose it in the chat, just because it gets a bit gnarly and unruly to kind of listen and type, right?
Got it.
So you may want to make your video anonymous, just because, this eventually will be edited, parts of this, and end up on social media. So if you're not comfortable with that, you don't have to have your camera on, obviously, because I'm just meant to receive the questions and thereafter try to pose a response which can provide some general guidance. In more complex cases, it may be necessary to get legal advice from a lawyer. I'm a lawyer, and we have lawyers in my office, or whichever lawyer you ultimately are comfortable with. So let me go to the question I see. So I see one. I'll just go sort of sequentially. So I see the initial question relates to somebody who completed her MBA last year working as a full-time machine operator. And started working and needs advice towards PR. So you might want to add a bit more detail, because the general economic categories relate to, if I sort of go by sort of, philo, genus, species, there's expressentry. Then within expressentry, there is Canada experience class and federal skilled worker and provincial nominee programs and federal skilled trades. So for that individual who posed the first question, I want to maybe get more detail from you. But in the meantime, I will see there's an additional question. Relates to potential entrepreneur. So the question is it better to invest and start in a business,
Yes.
or better to start a franchise? Okay, this primarily relates to entrepreneur programs. There is a distinction between the federal immigration system and the provincial one. So now, in the past few years, the provincial governments have their own immigration system, which is meant to target entrepreneurs, business people, which I'll focus on, amongst other categories. And it's deemed to be that they have more specialized expertise in whatever their provincial needs are in terms of potential business candidates. So with that in mind, focusing on the specific question, is it better to invest in your own business or franchise? So with that in mind, there is a preoccupation with demographics, namely people who are getting older in some of the areas of many provinces in the smaller towns. So in a situation when I try to determine what benefit would there be of a franchise, or what viability would there be of a franchise, as opposed to maybe getting your own business plan, a franchise could be workable in certain circumstances. I'll just pick the sort of edge case ideal, which is, for example, for illustrative purposes, in a small town where you have a dearth of food, they call it food deserts, where there's only processed food. In theory, a grocery store might be viable for that.
Okay.
I think my Siri was acting up there, but okay, so getting a bit distracted by the Siri, but I mean, in a specific case where there is a dearth of that particular service, and if it's in a small town, you could have like a franchise, if there's a real need. I mean, maybe maybe the small town has too many dollar stores and convenience stores. They want a grocery store. Maybe there's a franchise for that. Similarly, if there's a gas station that's too far away, that could be a franchise as well. So in other words, the answer to the question partly relates to the level of comfort you have with going to a disparate part, maybe a more remote part, or a smaller city within a province. And even if you're going to get a franchise, I mean, obviously you'd want to get independent legal advice, because you want to get a sense of the numbers and the viability and the amount of support you get from the franchisor in those situations. So in theory, then it's completely possible to have a franchise, as opposed to going through the more sort of bespoke method of having a business plan and using your related business acumen or business experience to forge a new business. And I think there's a related question to that, which is, so based on internet reading, the person says that they could go to Canada with their ETA, electronic travel authorization, and look for a business while they're in Canada on the ETA. Is it better, once the person finds a business to start, to stay in Canada and apply for the C11 work permit? which is like an entrepreneur work permit, or is it better for the visa startup program? Okay, a little bit dense, that question, but ETA is basically like a visitor visa for the developed countries. I don't want to get more specific than that. And then, so in other words, you're visiting Canada. There's nothing wrong with making an exploratory visit. In fact, if you look at the criteria for provincial nominee programs, I believe British Columbia, probably some of the others as well, you get extra points in their entrepreneur system by making an exploratory visit and visiting the provincial immigration officials. They're supposed to give you a little bit of general guidance and give you a sort of more tangible sense of what they're looking for, especially people who are composing business plans, which are relating, tying together their previous management experience to something they might want to do in the province. So that's definitely a good idea to visit. Sort of making this into a hypothetical, let's say you do visit, you find a business you want to purchase. I'll just get specific to the related question, which is, should I apply or can I apply for a C11 work permit? In that case, definitely yes. The idea is a C11 work permit is meant for employers, oftentimes who are going to be the manager themselves of this business. So when you compare a C11 on the other end, which is part of the question, to a startup visa program, the startup visa program, you have to get, as you know, if you've read up on this, you need funding from the approved. Well, first you need, the what are called, the angel investors, or there's a group that's approved by the Canadian Immigration Department. It's on the website. So you make a pitch to this group, and they say, yes, we like your idea, and usually they give you money or loan you money because they think the business is viable. But practically speaking, again, if I sort of use like an exaggerated case, there's a little bit of skepticism on the immigration department's part with startup visa programs because they're looking for innovation. So, in the ideal world, they're looking for like the next Shopify, which is Canada's big, software entity for this. It's not to say that it could be like something smaller than that. I mean, obviously, that's a sort of a unicorn kind of scenario, a highly successful Canadian company. But innovation is kind of the key. And that's why the sort of angel investors are on board with that. By contrast with when you look at the provincial programs, it's basically you're looking at how you're going to benefit the province. Usually the province is simply preoccupied with creating jobs and not doing certain types of businesses like, recycling or check cashing or passive investments. That's what the province wants to sort of screen out for this. One thing to keep in mind, though, with C11 is that the pathway for permanent residency is, at least temporarily, doesn't appear to be viable because in March, I believe, 2025, this year, they got rid of the extra points under express entry for executives, where you would get a huge amount of points, 200 points under the express entry system. And then the owner of the business, traditionally under C11, once they worked in Canada, once they had experience outside of Canada and then worked in Canada on the business, then they would use express entry as the federal skilled worker category based on the outside of experience, saying, I have senior management experience. Or they would use the Canada experience class saying, I'm an employee of this business, and then, but I am the executive manager, and they would get 200 points. Now, this I understand based on meetings that our advocacy group, the Canadian Bar Association, has had with the federal government, that the points will come back. But for now, it's a disincentive to consider C11 if the assumption is that you want to proceed to permanent residency after working on the C11 work permit. But again, this would change. So I just want to have that caveat in mind. I think I might have touched upon the C11 versus startup. If not, you can repose the question with a bit more specificity. In the meantime, I will see what is the next question. So I think this sort of ties into the initial question, which is graduating. If I just sort of scroll up here, right? Completed an MBA and then working full-time. And then if I sort of continue to the question, have experience in Canada only, but not what I presume to be high experience suitable under the Canada Experience class as it stands today. So the goal is to have a stronger pathway for permanent residency. So the traditional advice more recently is altered, because before the November 2024 changes, the CEC programs were favoring certain occupations, but now they're becoming more restricted. As a consequence, they're having what are called targeted draws. Those sort of started sometime in 2024. And the targeted draws are effectively only preoccupied with what are deemed to be in Canada's sort of economic job shortages. So traditionally, that's healthcare, a tiny bit of IT jobs like cybersecurity. I mean, the software jobs have dropped off in terms of selection since maybe early 2024. In other words, the overarching framework for coming to Canada as a student and then transitioning to permanent residency is not seamless anymore. In other words, you have to be strategic about what you're going to select and go on the assumption that after you graduate, the skill you require will be in demand in Canada. So then you will have a shot at express entry under the subcategory Canada Experience class. But because of the specificity of what the Canadian government is looking for, namely in-demand jobs, an MBA probably won't be useful in terms of the skill set itself unless you acquire a job that will be subject to targeted draws, which is, such as the aforementioned healthcare jobs and certain niche IT jobs, things of that nature. So if you have an MBA, it's very difficult to pivot out of that. There's a bit of specificity to that. So what do you do? In some cases, if you have an affinity with languages, then if you can get medium on the French TEF test and have perhaps 1 year of foreign work experience or 1 year of skilled experience in a more generic sense in Canada, then you could get a significant amount of extra points by simply having moderate French. And that could make you much more competitive, because they do have also not just targeted draws for certain jobs, but targeted occupations for French, right? So French experience or French language skills. So that would be one way to enhance your profile in light of the lack of, thus far, experience that may be the subject of the targeted draw. That would be the only tangible thing for this. They're sort of slicing and dicing these permanent resident occupations and pathways, but the recurring theme is in-demand jobs and French language skills. That would be sort of the ideal way to go. And also, to be competitive, rewriting your English language test, because there's an inordinate amount of weight given to language under the express entry grid. And I think I see a follow-up question with the sort of potential entrepreneur. So let's say there's a tire shop and the person is not in Canada, though the potential entrepreneur is not in Canada. They are in the ETA, they are in Canada. And then whether or not it's a franchise, if the purchase of the tire shop is carried out by the would-be business person, you can apply for C11. Is that permitted? Generally speaking, yes, but what you need in that scenario is a lot of specificity. So typically when you purchase a business, either by shares or by assets, then there is like a closing date for the business. So you want to negotiate a longer closing date, being armed with the processing time for a work permit. When you file for an initial work permit, the beginning one, most of the time you have to file it outside of Canada. Certain exceptions, like if you're applying for permanent residency as a spouse, or if you're applying for a PGWP. So depending on the country you reside in, you have to look at how long the work permit will take, and then you make the closing date longer than that work permit processing time. And then you should be able to get the work permit on time for the closing so you can manage the business. So there might be something related to that. Oh yeah, there's a question about what's the impact of age on would-be business candidates. So if an individual is 47, has no impact at all. Really, all they really want for would-be business people are money and somebody with business experience. Age is not a big deal unless you're, well, I saw somebody, I don't know if it was our firm, but somebody tried to do the business when they were like in their 60s. I pushed back against that. I think there could be an issue there, unless the nature of the business, doesn't really matter about the age, but that's sort of a borderline edge case in a sense. But with that in mind, if there's a follow-up question of that, go into the chat. I'll sort of go sequentially again here to what I see next is related to somebody in the United States. So somebody residing in the US as an asylum seeker without a decision on their US-based US asylum claim with an expired passport. However, the same individual is working as a software engineer with 7 years of experience, a master's degree in electrical engineering, so highly specialized, even more so speaking French and English. So what are the possibilities for this highly skilled person to move permanently to Canada? So one issue is for any economic category, you have to get a valid passport to even consider filing, assuming that there's a serious issue here, because if you're claiming asylum, then oftentimes there may be a fear of returning to your country, and sometimes applying for a passport could be seen as contradictory to that, because under refugee law, you're deemed to be seeking the protection of your government by simply filing for a passport. I know it's very idiosyncratic, because what does simply going to a consulate have to do with getting protection? How are they going to know what your fear is in the country? But that's the way the refugee law is stated. So you may want to look at the basis for your refugee claim and look and get independent legal advice from a US attorney about the chance of success and the timeliness of that refugee decision in the United States, because things are quite frankly quite unpredictable in the States. But if we set aside that issue, let's say you can somehow get the passport and not sort of jeopardize your US asylum claim, then there could be a potential admissibility issue, because a lot of Canadian immigration statutes and regulations are concerned with whether you had valid entry in the country you're currently in for this. If you did have, let's say, 6 months of entry, then maybe your status lapsed in the United States. It may not be a big deal. But in a situation where, in some cases, these may not be common, but there's a minority of refugee claimants in the United States which may have had some connection to human trafficking, and may have, during the course of that, been prosecuted by the FBI for carrying a fake passport. They're not supposed to do that, because it's sort of not uncommon for asylum claimants to go to desperate measures. But sometimes these allegations end up in the FBI system, and then there might be an admissibility issue. So you may have to tackle that with an additional application on top of the permanent resident application, such as a temporary resident permit, which is meant to cure inadmissibilities such as criminality or health issues or things of that nature. But aside from those things, everything else looks amazing, assuming you're under 35, because I didn't catch the age there, because if you have French and English, electrical engineering, I mean, depending on if there's a niche type of software that you're doing, that could still be popular. And the foreign work experience would count towards the federal skilled worker category up to about 3 years or so. So if you have 3 years plus a master's in something very specific, you still could be viable as a candidate. So I'll go sequentially again. So I think the would-be entrepreneur said they're from Belgium. Belgium's good because I believe the visa office that handles Belgium might be Paris. I mean, sometimes it's an in Canada office because it's electronic, but that means the processing time might be fast for a work permit, and then the entrepreneur could negotiate a favorable time to close the business in that scenario, right? And there's sort of a follow-up there, going back and forth a bit, right? So it's, as I mentioned earlier, about applying for C11. So yeah, that's fine. I mean, if it's Belgium, if the sort of nightmare cases are if you're Bangladesh or India, where the processing time is pretty crazy, or Philippines, extremely fast, and then it becomes problematic, right? Age 43, sorry, shifting back to the electrical engineer from the States, age 43 could be a problem because the points start to max out at age 35 for express entry. I mean, that being said, if you do have French, if you're fluent in English and French, you could conceivably be competitive on the points, just because they really truncate it, they really lower the points when you have French language skills that are fluent in particular. I see sort of a new question here. I don't know if it's related or if it's an initial question. So somebody's in the US as a Fulbright J1 visa holder. So it's a study permit, I believe. And that will expire this year, very soon, end of August. Holding a PhD and currently working as a climate-smart agricultural researcher at a university, 45 years of age, with French and English. So this kind of echoes, to some extent, the previous question, except this person has less of a problematic status, namely J1 visa holder. So I believe they can study and or work part-time in the States. The idea here is that with the French, there's what I already mentioned, the targeted draws. And what I neglected to mention, which may be applicable to the earlier question of the asylum claimant. I mean, depending on your financial wherewithal, if you could get admission to, I mean, this might be a step backwards for this individual who's a PhD, but for the other person, you could consider getting a master's, because I believe Manitoba and Ontario have a master's stream. And if you graduate from the master's, then there's a direct pathway for permanent residency as long as you indicate you intend to reside in that province. But touching further on this particular question, where the person is a PhD working in a field, looks like a very technical field. In that case, arguably, I mean, normally we say there's getting a job offer is a theoretical part of getting PR, but it's practically speaking very difficult to get a job offer if you're not in the country, not in Canada, except for maybe highly specialized IT where they don't really need to see you in person. They just want to see your portfolio. But if you're dealing with something highly specific, it's something worth looking at. There's the official Canadian government job bank, jobbank.gc.ca, for somebody who's highly specialized in terms of skills. And that would be sort of, I think, applicable to try to explore another possibility for somebody who is working in something highly specialized with a PhD. Because if you have I don't mean to stereotype, but if you have like an arts PhD, obviously the applicability in the labor market is quite limited. But if you have a highly specialized PhD, you could find a niche employment set of employer, maybe, and then get a certified job offer, which is namely an LMIA. And then from there, you work in Canada for that. And then the points you've already accumulated from your outside of Canada work experience, plus you're already fluent in English, and plus 1 year Canadian experience, that might compensate for being, age 40 or age 45, because then you're having a highly favorable profile. And as I indicated, the express entry draws, they drop periodically to a much lower required score if you have French language. So In that scenario, if you have, for either of these two people who pose questions, I mean, if you're fluent in English and fluent in French, it doesn't hurt to place the expressentry profile into the system, because the points could drop for these targeted draws. For the others who don't have this, honestly, the points, if you're not going to be subject to the targeted draws, then the points are not going to go down until 2027, because the government is trying to reduce the amount of permanent residents for 2026 and 2027, and we're still only in 2025. So that means in the meantime, it's going to be targeted draws for this. There is a follow-up to the very initial question, which is if the MBA was done in British Columbia, is there an advantage? So that's really the same thing as saying, in my mind, it's the same thing as saying, is there anything under the provincial nominee program for British Columbia for this? British Columbia has its own occupation list for occupations under pressure for this. And if the skill you acquire is on that list, then you could be subject to a possible pathway. But keep in mind, the provincial nominee programs, if we exclude the entrepreneur ones, most of the time they're meant for people who work in British Columbia, usually for at least 6 months, and have a job offer from a BC employer. And then, in other words, that means the British Columbia employer has to scrutinize, or rather get scrutinized, by registering with the British Columbia government. And it's really just for the purpose of showing that they are a viable business. That's usually an operation for a year. And then they're registered. And then if they offer you a job, then that could be a pathway. So that would be the utility, possible utility of having the MBA done in British Columbia. In other words, a job offer. So sort of looping back to one of the entrepreneur questions, focusing further, is it better to look for a job in Canada or start a business to immigrate? For a situation where the person doesn't look like they have post-secondary or university for this. So the short answer is yes, because the express entry system, they have this idea that more education is supposed to be indicative of higher chance of employment, although now with artificial intelligence, I don't know what's going to happen with that. But in this case, the combination of being over 35, in this case 47, it is better if, as long as you have business experience. Usually they want 2 or 3 years of business ownership and management, or 2 or 3 years of executive management in a business endeavor that has made money in the past 2 or 3 years out of 5. If you have that, then it's better to pursue a business. Obviously, the initial money needed is more significant. So a lot of these provinces, they want a minimum of 200,000. That's if you're going to have a business in a smaller city. I think British Columbia, if you want it in a larger city, I think they want 350, and I think a net worth of 650 Canadian thousand. Ontario's paused their program, and I think it was kind of the same. So now turning to something different here, somebody said they've submitted a PR application under humanitarian and compassionate grounds. So can I apply for a work permit? So humanitarian grounds, like 90% of the time, if you file a H&C, humanitarian compassionate application, you're inside of Canada. And the question is, can you, instead of working without a permit underground, is there a way to acquire a genuine work permit? Well, firstly, it's advantageous if you have a H&C to try to get a work permit, because some judges at the federal court say that, no, we shouldn't really count that work experience if it was illegal. That being said, other judges at the same level have said, no, it's not a big deal. So there's a bit of a gap or ambiguity in the law about that. But getting to the specifics of the question, it really depends on how many steps or appeals you have exhausted while in Canada. And so that means, for example, your history in Canada. For example, some people, they made a refugee claim, and then that was denied, and that put them on track for a whole host of other appeals. So after refugee, there's refugee appeal in many cases. After that, there's federal court. And after that, there's a pre-removal risk assessment. So that's one set of pathways. And if the pre-removal risk assessment has also been decided negatively, then it's much more difficult to get a work permit because you are what's called, not always, but you're oftentimes deemed what's called removal ready, which means that there is no legal impediment to remove you. And then if you apply for a work permit, you've got to pay the government fee, $255 or whatever it's gone up to now. And then you have to make the case that I'm not removal ready, despite the fact that I've done all of those things. Could be possible because sometimes there is still an impediment. Maybe the country you're from, they can't get you a passport. So that means the Canada Border Service Agency cannot get you on the plane. In that case, you can make an argument that you're not removal ready, and so you should be issued a work permit. So that's one instance. There could be some other nuances. Let's say you came as a student and then went and, let's say you worked for a couple of years and then maybe went underground, and then you want to file for a work permit after, let's say you filed a humanitarian case. In that situation, it's almost the same. It's just that if you have not done all of those, in particular, if you've not had the opportunity for a pre-removal risk assessment, you could still file for one. So, that's sort of the general guidelines for when you can file for a work permit in a situation where there's a humanitarian. One thing I didn't mention, which is there is the role of, I mentioned in a different context, a TRP, a temporary resident permit. And again, depending on the circumstances of how long ago your status lapsed, sometimes people can, if they had a minor violation of the Immigration Refugee Protection Act and regulations, they could use a TRP application plus a work permit application. That's for the purpose of trying to completely regularize their status after having it lapse. But you really need legal advice for that because we don't want to do those unless we see the merits of that.
Cool.
And then, let's see, maybe looks like a follow-up to the would-be business person. So let's see. Already from here in Belgium, apply for C11 when there is no job or business in Canada. Okay, so the question is really when you're applying for a C11 work permit, in any circumstance, the way to enhance it is with specificity, but it's got to be really specificity that is showing that you have a commitment. So, in this age of remote meetings and things of that nature, if you have something very specific, such as what I touched upon earlier, where there is, let's say you hire a lawyer in Canada who does all the legwork.
Yeah.
You give that lawyer your passport. The lawyer has a power of attorney. Lawyer opens a business bank account in Canada for you. The same lawyer, maybe as a corporate lawyer, they negotiate the business and you give the lawyer the money to buy the business. Let's say you do that all remotely. Then the immigration or the visa officer in Paris is going to say, wow, this guy's serious. He's transmitted the money. There's a closing date, 90 days from now. Then all they're going to be preoccupied with is whether you have, obviously there's admissibility, like criminality or whatever, but the main thing they'll be focused on is, does your business experience show that you can do the job that's going to be performed in that work permit? As long as you satisfy them about that, then you should be fine. Although they don't interview people that often for work permits, they might want to interview you for this because this could benefit, the destination where the business is and not just benefit you. But in that case, you'd need to show what I touched upon earlier, which is the good business track record, hopefully in something related for that. So the short answer is yes, with all of that sort of set of caveats, right? So what are we doing for time? Oh, we still have 15 minutes. So I don't see any other questions now. So please feel free. There's a number of people here. Could be something to pose in terms of this. Shameless plug is that we do all of these applications, and we also do the federal court, which oftentimes clients who self-file, they get refused, and there's no other redress for them except federal court. So we have lawyers in our office that do federal court as well for this. But going back here, right? Oh, yeah. So I think there was maybe a related question, which is, let's see. So can I apply? Oh, for permanent residency, I'm reading into the question. Maybe that's not the question, but can I apply outside of Canada for permanent residency without having a job or business in Canada yet? So the short answer is yes. No, rather, unless there is some connection between the skills and a program or pathway here. In theory, the outside of Canada candidates that are allowed are the subcategory of express entry known as federal skilled worker. And for a federal skilled worker, it's outside of Canada experience is sort of the hallmark or the sort of cornerstone of that. But keep in mind, that's as the categories are job-based, practically speaking, and there's a bias in terms of age, then that's a very narrow niche of people. This is in contrast to maybe 6 years ago, where we had a number of people who were outside of Canada and they were successful under express entry, but the points were much lower. And in those cases, even then, the person did need at least 1 year of work. Obviously 1 year, sometimes 2 years of work experience and a master's in that sort of pre-COVID kind of era where it was somewhat more common for people with outside of Canada work experience under FSW to immigrate to Canada. But now it's really getting quite rare, unless under 35, French speaking and or highly in demand work experience like niche IT and healthcare, things of that nature. And oddly enough, if you look at the current list, there's jobs I wouldn't have thought, like insurance agent, which I didn't know there was a shortage of in Canada. Other jobs I believe on the list, I think, are teacher. But with teacher, I think you have to get a license first, which means they're really looking at people who are already in Canada for that kind of occupation. So with that in mind, I think I see another question here. So this may be relating to delay. So it says the person's PR application was submitted more than 10 months ago under the CEC, Canada Experience class, and it shows security in progress. Is there any way to expedite the process? So this is where whenever there is a issue of security, then what comes to my mind is, what profile are you presenting to the immigration department? And the profile of concern is that, and this may not be the situation, but just off the top of my head, if you worked for the police in certain countries or the government in a high up position, let's say they don't have a good reputation. Maybe there's a history of police brutality or things of that nature. I had a case where the person was a senior official in a certain African government, and that government was accused of human rights violations, and they were part of the intelligence agency, and so they were excluded completely. These are obviously like sort of exotic cases which relate to admissibility. In some cases, some people simply have the same name as somebody else. Sometimes it's same name, same date of birth. So they're concerned about, is this the person of interest? that is a security threat, or is this somebody else? That's actually happened once in the 30 years I've practiced, where their case took like 3 years just because of that fact, same name and same date of birth. It was a common name from Iran, right? So, but in terms of expediting the application, the problem is with whenever it comes to security, the standard answer is that immigration, IRCC, has to liaise with third parties. Usually the third parties might be governments of other countries. And then they're waiting for the response from the government of the other country. And then sometimes Canada's immigration department drops the ball and just doesn't follow up. And then that could lead to a delay of potentially 2 years, I've seen. And that's a far cry from the ordinary processing time of 6 months for CEC, assuming you filed everything. So there is a risk or a danger that the case may be in limbo, and then you may have to explore what's called a demand letter. I mean, this is obviously after you've tried the web form or the client-specific inquiry, where you shoot an email through the portal. I've found, though, that whenever it's security, then all you'll get is a boilerplate response. So when it gets to the point where it is past the ordinary official processing time, and you've done the web form /CSE, and you're getting a blank or general response, then you might have to consider a demand letter. A demand letter is basically a formal demand in the framework of the, I think, the Federal Court of Appeal case of Apotex. And that sets out the criteria for when an individual can demand a decision by a government official. One thing to keep in mind is you have to show prejudice. Well, I mean, that's not mandatory, but it seems becoming mandatory that you have to show prejudice because of the delay. For example, maybe you want to get a job that requires PR as opposed to a work permit. Maybe you need a promotion. Maybe you're working for an employer. They want you to get Canadian PR so you can travel more easily, instead of maybe you're on a Indian or Pakistani passport and it might be hard to enter certain countries. And then if the demand letter doesn't work, let's say after 21 days, and you have to go to federal court and do mandamus. So mandamus is basically make a decision. So the federal court review whether your case fits the Apotex framework, and then order the immigration department to make a decision within, subject to updated police clearance and medical, unless police clearance was the issue, within a certain amount of time from the date of the judgment. So that might be the, hopefully not all of the steps, but I mean, that might be the solution you might have to consider in cases like this. So I see a related question to a business person, which is there a resident permit with C11? So I spoke about TRP, temporary resident permit. So normally, let's say if you're outside of Canada, the only time you'd consider a TRP is, let's say, if in your history there is criminality, and let's say the punishment, if the same offense was done in Canada, the punishment was potentially more than 6 months in prison, then that could be deemed criminal inadmissibility. So then in that circumstance, you say, look, I've got this business. It's going to close in 90 days, but I have this criminal record, and I need to enter Canada despite this inadmissibility. So you'd have to file those together. And this is sort of hypothetical, right? And then the officer would weigh the need of you to enter Canada, namely to start this business that you've invested in, versus the risk to Canada, namely the offense. So if the offense took place more than 5 or 10 years ago, that's a positive sign. And then if your life has been relatively stable, then you could be considered to be successful for the TRP, because the need is high for you and the risk to Canada is low for this. So it's sort of a hypothetical, but otherwise we don't really see TRPs as being necessary unless you're coming with a family, and let's say a spouse is medically inadmissible. Let's say they have a medical condition that will cost more than, I believe it's $23,000 in a year. So that'd be medical inadmissibility. And then you'd say, well, we have a mitigation plan and we still have to come because we have a business or things of that nature. And the whole needs versus risks aspect would be considered by the officer for this. So with that in mind, I wonder if there's any other questions. Taking a look here. Let's see. Okay, I see something here. So a lot of Belgian-themed questions today. So my wife is a Belgian citizen with a master in cellular, biological, and industrial biochemistry with 4 years experience living in the United States. And we have 3 children. So what are the possibilities for her to move with the express entry pathway? So if I sort of digest the question, so Belgian citizen, so usually they don't really, I'm not a US immigration lawyer, but I think they usually have an easy time to enter and re-enter the United States and Canada too, usually, right? And with the masters, that's a plus, as I've indicated earlier, more than 3 years experience. So you can max out the FSW or federal skilled worker points residing in the United States. 3 kids, I'll assume for the moment, are under 22. If not, you can correct me if I'm wrong, right? So the key, which I want to reiterate, is that master's is good. If the work experience relates to something in biology, that probably is on the list. And again, like I think chemist might be on the list as well. If it is, then you have to do the basics, which is write the language test for English and, if applicable, French. Make sure your passport is valid. Make sure you get the educational credential assessment for the foreign work experience with all of those documents. I mean, hopefully you're under 40, because I think, or under 35. If not, I mean, it still might be worthwhile because of the masters. And with all of that material, make the express entry profile. And then hopefully even in this year and next year, where the points are still targeted because they're delaying or they're reducing the amount of people, it's a good pathway. So 40, age 40, I think it's still viable. You don't have that much to lose with an express entry profile because you're not paying the government fees, which are like, $1,000 per adult. It's just a profile. So as long as the profile is done well, I mean, if you're not comfortable doing it, you can hire a lawyer. We do those as well. Shameless plug as well. So we can maximize that. If you're married, and if you, the spouse, are fluent in English and French, you should also write the language test because there could be benefits to that as well. In terms of the process for that scenario, then with express entry, keep in mind the express entry profile is valid for 1 year. So what that means is that in the best case scenario, you do the profile. Let's say there is a targeted draw for something related to the work experience you've accumulated, which was connected to cellular, biological, industrial biochemistry. Then the points would be reduced. And then let's say you do the profile, and let's say you, in the best case scenario, these draws are every 2 weeks. The best case scenario, instantly 2 weeks later, you get selected. Then what happens is you're given 60 days to complete the application for permanent residency. So that means you have to get your police clearances and all of that stuff and the forms. And then from the 60 days, there'll be a completeness check email saying, yes, we've received it. And from that completeness check time, it's supposed to take 6 months to get the PR. And so that's sort of how the system was supposed to work. And it sort of works for a lot of these people, right? Except for the earlier person who posed a question where security sometimes comes into play. So that's sort of the best case scenario. So I think we are almost at time. I'll look at the chat if there's anything else. I don't think there is, but I hope this was helpful, and thank you for joining, and I hope you enjoy your weekend as well. You're very welcome, right?
Yeah. Nice weekend.
Okay. Thanks again. Have a good one. Thanks. Bye-bye.